Hello, and welcome to Book Contracts 101 with the Authors Guild and our Director of Legal Services, Michael Gross. Michael has a presentation on the important terms to negotiate when considering a traditional publishing contract. We'll focus on critical provisions and what to avoid. Now, we have a lot of Authors Guild members here. I hope you know that you can submit legal questions to our attorneys. If you're an emerging writer member and you receive a traditional contract, you can upgrade your membership to the professional level and access our legal advice. And non-members, I know we have a group from Sisters in Crime here. Some of you might have heard about this on social media. If you join the Authors Guild, you have access to our attorneys. You can submit your contracts for review. You can submit any writing and publishing related legal inquiries you may have to our attorneys. They can provide expert advice. I'll just say one disclaimer: this webinar is for informational purposes only and should not be construed as legal advice. And with that, I'll introduce Michael Gross. Michael completed his undergrad at Syracuse, where he graduated in 1996 with a Bachelor of Science from the School of Management, majoring in law and public policy. He then went on to complete his legal education at New York Law School, where he graduated in June of 1999. And Mr. Gross has been with the Authors Guild since then, where he now serves as Director of Legal Services. He regularly advises members on a wide range of legal issues, including contractual issues, First Amendment issues, copyright, trademark, immigration, and tax issues. And with that, let's get started with Book Contracts 101. You can use the Q&A box below to submit any questions, and we'll try to get to as many as we can at the end. Michael, I'll turn it over to you.
All right. Thank you very much, Johnny. Good afternoon, authors, and welcome to Book Contracts 101. Before I get started, I just want to talk a little bit more about what Johnny was describing, what we do at the legal department. As a full-fledged guild member, you are entitled to free line-by-line reviews of traditional publishing contracts governed by U.S. law. We review movie and TV options. We review agency agreements. We review freelance and independent contractor agreements. We review licensing agreements. All sorts of other agreements too. If you have a contract, you can send it through our website when you log in as a full-fledged member, or you can submit it to staff@authorsguild.org. We also give copyright advice. We intercede in contract disputes. We help members obtain the reversions of rights and provide many other types of assistance. Now, moving on to today's seminar. This seminar is intended to introduce you to some basic but essential ideas to keep in mind when negotiating your contracts or when evaluating a proposal presented to you by your agent. We're going to go into presentation mode now, so let me share my screen with you. Hold on. Here we go. Can everyone see the Johnny? Can they see the screen now?
Yes, looks good. That's great.
All right. Perfect. Then let's get started. Quick note: Christy will not be with us today. She had an emergency, and everything is fine, but she will be back in the office later. Now, as far as the seminar, Contracts 101. What should I focus on first? Whoops, hold on. This is not working. Perfect. We are ready to go. All right. What should I focus on first? When first presented with a contract, many authors feel understandably overwhelmed. There are so many potential issues to negotiate that many throw up their hands and just sign whatever's in front of them. I'm here today to tell you that that is not okay. There's no need to ever do that. Above all else, I think there are three important categories that are most important for an author to focus on first. I think of the first category as the rights you as the author are asked to give up. These rights include ownership of your copyright, the grant of primary and subsidiary rights, and how to terminate the grant of rights, which would be achieved with a strong out-of-print provision. The second category is the money you will receive for licensing the rights to the publisher, which includes the advance, primary rights royalties, subsidiary rights royalties, and the accounting and auditing provisions. Finally, the third category is the warranties and indemnities provision. We'll explain each one in turn. Now, first, we're going to discuss copyright. The notion of copyright is actually embedded in the Constitution in Article 1, Section 8, Clause 8. This clause empowered the U.S. Congress to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Right now, copyright protection for individuals lasts for the life of the author plus 70 years. For the purposes of writers like yourself, essentially, once you write something down or type it onto a computer, a copyright protection attaches to your words. As a copyright owner, you possess the exclusive right to make copies of your work, distribute copies of your work, perform your work publicly, such as for plays, films, dances, or music, display your work publicly, such as for artwork or stills from audiovisual works, or any material used for the internet or television, and you can make derivative works, including making modifications, adaptations, or other new uses of a work, or translating the work into other languages or media. In the case of the author-publisher contract, you are licensing some or all of your rights comprising the copyright to your publisher, almost always on an exclusive basis. Now, as far as negotiating the copyright provision in your publishing contract, you always want to make sure that the copyright is registered in your name and your name alone, unless you have a co-author in which you want it in both of your names. If the publisher manages to secure language to register copyright in its own name, meaning the publisher's name, rather than your name as the author, that's the equivalent of making the transferee, i.e. the publisher, into the author and cutting you, the actual author, out of all benefits to your work unless specified in the contract. The opposite should be the case. You always want to retain copyright in your name and only grant specific rights in that copyright. Most book publishers are willing to allow the author to retain copyright. The only exceptions are really university presses, which really push to obtain copyright, but sometimes they will negotiate that. Now, assuming you're able to retain copyright, ideally, you want your publisher to register the copyright in your name within 3 months of initial publication. If your work is registered within 3 months of initial publication, you are entitled to pursue statutory damages and attorney's fees if the work is infringed. Failure to register within this time can result in your being denied these types of damages if your work is infringed. Finally, make sure that all licensees of your publisher are required to print a proper copyright notice in every version that they produce. We'll now move on and talk about the grant of primary rights. Now, assuming you've retained copyright, you must next decide what rights you want to grant to the publisher to exploit. These rights are called primary rights, rights that publisher will directly exploit itself. These days, most publishers are seeking to exploit both electronic and print rights themselves. In regards to granting electronic rights, you want to pin your publisher down to exactly what plans it has. Ideally, you only want to license a verbatim text edition in electronic form so that the publisher can issue your work as a traditional true to form ebook. In regards to the print edition, you should try to limit the publisher's print rights to English language editions sold in the US, its territories, and Canada. If you have an agent or your publisher is small and doesn't have a foreign rights department, it may be in your best interest to reserve foreign rights for yourself, or only grant such for a short period, such as 2 to 3 years. So if they fail to exploit foreign rights within that time, the rights automatically revert back to you. Finally, publishers are more and more insisting on retaining audio rights as well. If you cannot retain audio rights, try to limit the grant of audio rights to 2 to 3 years after initial publication. Then the publisher must so-called use it or lose it. That means that if the publisher does not exploit those rights in that 2 to 3 year period, you should have the right to send a termination notice and reclaim the audio rights for yourself. We'll next talk about subsidiary rights. When you grant subsidiary rights to your publisher, this means that you're granting your publisher the right to license the publication of your work, either in its original form or in a different format than the original, to third parties. We normally recommend that authors try to reserve non-print rights, which include multimedia rights, film adaptation rights, television rights, radio rights, dramatic rights, and commercial or merchandising rights, as well as foreign rights, including foreign language rights and foreign territory rights for themselves. This is especially true for authors who will be published by smaller presses, which may not have the adequate resources or the necessary experience or contacts to effectively exploit these rights on your behalf. For instance, Smaller publishers may not have the connections necessary to sell the German translation of your work abroad or option your work to a film production studio. However, if you do decide to grant all or some of your non-print and foreign rights, make sure the grant is narrow so that your copyright stays intact. For instance, today we're seeing some publishing contracts that try to lump every conceivable electronic right, including interactive multimedia rights, under what should be a basic ebook provision. Ideally, the publisher should only be entitled to license a verbatim text rendition of your work, as mentioned before. Its right to license your work for other electronic uses, such as an interactive game, should ideally be reserved to you. However, by using over-inclusive language, such as all other electronic rights now known or hereafter invented, or in any electronic form, publishers thwart the basic grant so that they may rightfully exploit your work in ways that aren't even invented yet. So authors must be extra vigilant in negotiating these clauses. At the end of your subsidiary rights clause, it is always wise to state that all rights not specifically granted to the publisher are reserved to the author. Now, we're next going to talk about the out-of-print clause. It might be the most vital clause in your contract, to be honest. In regards to the majority of traditional publishing contracts, publishers will seek to retain the right to exploit your work for the entire duration of copyright, which you've already stated is the life of the author plus 70 years. While the Copyright Act does provide for a statutory right of termination, which begins at the end of the 35th year after initial publication, or 40 years at the date of contract execution, most publishers will have lost interest in marketing an author's work long before that. Accordingly, the out-of-print clause is the only way for you really to regain your rights and seek republication elsewhere once your publisher has stopped meaningful exploitation of your work. Once an author's work goes out of print, as defined in your agreement, you should have the affirmative right to demand that the publisher either reprint your work within 6 months of a request to do so, written request to make that, or revert all rights, including electronic rights, back to you. To this effect, when negotiating an out-of-print clause, the definition of what constitutes a work being in print or available for sale is key. First, make sure there is not a time restriction on when you can seek reversion of rights. Some publishers try to stipulate that the author cannot seek reversion until at least 5 years after the date of initial publication. The fact is, most publishers are done with a given work after 2 years, maybe 3. So changing, that 5-year period is key. Make sure that if there is a time frame within which you cannot seek reversion, it does not exceed 3 years. Next, you should try to define your work as being in print only when copies are available and offered for sale in the US through normal retail channels in an English language, hardcover or paperback edition issued by your publisher and listed in the catalog issued to the trade by your publisher. With the rise of print on demand and ebook technologies, it's critical to include language that makes it clear that your book will not be considered in print if it is only available through these technologies. Failure to do so could prevent you from rightfully reclaiming your rights through the reversion process. To best protect yourself, we recommend stipulating that if your work is only available via print on demand or ebook, it will only be deemed in print if you, the author, receive a minimum floor in royalties over the course of 2 consecutive 6-month royalty periods or any 12-month period. The minimum should be 150 to 300. Many publishers will seek to use a sales floor, where if they sell, say, 200 copies over 12 months, the work will be considered in print. However, this method allows the publisher to heavily discount those copies to meet that minimum sales threshold without you, the author, being paid barely any money. This is why using a fiscal floor, a monetary floor, is key for out of print. You never want to use a sales floor because it guarantees you no income. That being said, let's talk about income. We're going to talk about some money provisions next. Let's first talk about the advance. As many of you know, an advance is a payment made to an author prior to the author's earning any royalties from sales of the work. The advance then offsets royalties earned. That is, authors won't receive any further money from the publisher until their advance is fully recovered or earns out from sales of their work and subrights. In theory, an advance is supposed to pay for an author's pre-publication expenses, which is why we advise our members to either try to negotiate for a lump sum payment on signing or at worst, signing, delivery, and acceptance, not on publication or post-publication, which a lot of the bigger publishers, Penguin, Simon & Schuster, Random House, will insist upon. As to the amount of the advance, historically, publishers have paid advances based upon the amount of money they would expect to pay the author from the first print run of the work. However, with ebooks and POD and audiobooks being delivered digitally, these formulas are kind of moot at this point. At this point, it's more of a negotiation based on reputation. Obviously, past sales plays a factor, but really, it's how well you're known and how well your work is known and the interest that your work would generate. So moving on to royalties, I put together a list of rates that many adult trade book publishers are willing to pay their authors. The largest publishers, such as the Big Five, Penguin, Random House, Hachette, Harper, Simon & Schuster, Macmillan, routinely offer the following hardcover royalty scale. 10% of the list price, also known as cover price, on the first 5,000 copies sold, 12.5% of the list price on the next 5,000 copies sold, and 15% thereafter. For trade paperback royalties, these publishers usually offer a flat 7.5% of list. However, some will escalate to 10% of list after 20,000 copies. That was the old standard, but few publishers are paying more than 7.5 of list at this point. For mass market paperback royalties, these large publishers are paying 8.5% of the list price on the first 150,000 copies sold and 10% of the list price on all copies sold thereafter. However, this is the exception, not the rule. Most publishers are not paying list-based royalties. Most small to mid-sized publishers pay royalties based on the publisher's net receipts rather than the list price. When a publisher pays on net receipts versus a list price, the publisher has room to offer rebates or other special deals to purchasers, such as bulk sales, or to write off bad debts to defunct purchasers who didn't pay, all without paying. You wouldn't get royalties if the publisher's not getting the money from their purchasers. So that makes a lot of sense for the smaller publishers who have much smaller budgets and can't afford these kind of losses. With small to medium-sized publishers and academic presses, many authors are able to negotiate for hardcover 10% of the publisher's net receipts on the first 5,000 copies, 12.5 of the net receipts the next 5,000 copies, and 15% thereafter. In regard to paperback copies, these publishers usually pay a flat 10%. Some academics might go as low as 8%, but I would still push for 10%. Now let's look at some of the special print rates. Many publishers will reduce royalties based on foreign sales of an author's work. Authors often receive, at most, 2/3 of their regular rates from export sales and as little as 1/2. However, some authors are able to negotiate their full royalty rates for Canadian export sales. One more point with this I'd like to address is the fact that many publishers reduce their royalties when they sell their authors' works at what is known as a deep discount. When a publisher sells copies of a work at a discount rate of 55 or 60% off the list or cover price, many publishing contracts will automatically cut the author's royalty in half for those deep discount sales. We at the Guild take the position that the authors should protect themselves by specifying in their contracts that the provisions of the deep discount royalty provision will only apply when the deep discount is given to a purchaser not ordinarily engaged in the business of bookselling, and where it is not expected that the book shall be sold where books are normally sold at retail or wholesale. This is known as a special sale. In regards to the specific deep discount arrangement, and you might wish to write this down, you might try to stipulate that the applicable prime royalty rate will be reduced by 0.5% for each 1% reduction over your publisher's triggering rate. That is the discount rate that would trigger the deep discount provision. For example, if the deep discount rate is 55% off the retail price, you might ask that your regular rate be reduced by 0.5% if it reaches 56%, and another 0.5% if that discount goes to 57%. It is also best to try to set a floor on your royalty rate for deep discount purposes, so that in no event will you receive a royalty less than 2/3 or at worst 1/2 of your regular royalty rate from deep discount sales. Unfortunately, many authors find their publishers sell a lot of works at a deep discount royalty, so negotiating a strong deep discount provision is important. We'll next discuss ebooks. Royalties for ebooks, even those produced by university presses, are hovering around 25% of the publisher's net receipts at this time. And this is for from the largest to the smallest. Even the Random House, Simon and Schuster, Big Five, Big Four are paying 25%.
Hey, Michael, excuse me.
Yep. Sorry.
I think it would be helpful to define the net terms, net receipts a little bit more.
Sure.
If we're wondering about that. Mm-hmm.
I could certainly do that. Net receipts is what the publisher takes in. I have some definitions that I like to use for net receipts. I don't have them in this presentation right now, but when people get contracts, I could certainly recommend definitions to you. Basically, you want to make sure that it limits what the publisher can deduct. As far as bad debts is okay. As long as they're not deducting production costs, inventory costs, warehousing costs, shipping. Well, sometimes shipping is okay. But yeah, production, marketing, that kind of stuff, you want to make sure that any definition of net receipts does not allow the publisher to deduct those types of costs. It should only be able to deduct like freight, bad debts, foreign currency conversions, things like that. Basically, whatever they're taking in is what you should be paid off of without them deducting much, if anything. I hope that clears up a little bit of the definition of net receipts. But again, whenever you get a contract, you send it in, I will scour it, or someone on my team will, and we'll make sure that the definition of net receipts is kosher. So Johnny, you think that's sufficient?
Oh yeah, that's great. And then so list is literally the suggested retail price.
Yeah, list is the price that you see on the cover of your book or on the back of the book, on the spine. List is that set price that's written on the actual book. Yeah.
Great, thanks.
Cool. All right, so we'll focus on ebooks now, everyone. Again, royalties for ebooks, even those produced by U presses, are hovering around 25%. Although for years, publishers paid 50%. We're not sure why they uniformly lowered this rate, and we at the Guild have made our feelings known about this for years. We did math on it, and we feel the rates should remain at least 50%, considering a lot of publishers make more on ebooks than they do on actual hardcovers. And the author does not. So it's a skewed relationship. While you may be unsuccessful in negotiating 50% at this time, ideally you want to add language that would allow for an automatic right of renegotiation after initial publication, such as through 2 to 3 years from the date of initial publication, whereby you'd be allowed to at least renegotiate. Some contracts will say that if that publisher has across the board raised the rates, that it would automatically apply to your contract. But you do want like an affirmative time period, a clear-cut time period where you can have that right to say, hey, let's renegotiate this. Okay, moving on to audiobooks. Many publishers will pay the following royalty scale for audiobooks. 10% of the publisher's net receipts on the first 10,000 copies sold, 12.5% on the next 10,000 copies sold, and 15% thereafter. In regard to downloadable electronic copies of the audiobook, like ebooks, many publishers are paying 25%. That's pretty standard as well. We will next talk about sub-rights royalties. An author's subsidiary rights royalties is your split of the income received by the publisher from all of its licensees when it licenses rights in your work to a third party. Almost all reputable publishers pay a minimum of 50% of its net receipts to the author from the licensing of domestic print-related rights, such as reprint rights, abridgment rights, or excerpt rights. However, most reputable publishers pay their authors a much higher percentage share of their net receipts from their licensing of dramatic rights, which includes movie, TV, radio, as much as 75 to 85%, first serialization, which is really 90%, commercial, 75 to 85%, multimedia, 75 to 85%, foreign sales, 75%, British Commonwealth, 80%, and translations, 75%. So when you see rights that are below, when you see rates, sorry, not rights, rates below 50%, that's a huge red flag for me, and it should be for you too. So you always want minimum 50% and much higher for these other rights listed here. All this is also in our model trade book contract, which is on our website. We'll next discuss accounting and auditing, other critical money provisions. Our preference for accounting clauses is that the publisher be required to render royalty statements and payments at least biannually, if not quarterly, within 3 months of the close of a given accounting period. While many publishers have rigid reporting periods that are non-negotiable, keep the previous suggestions in mind, especially when it comes to their duty to render statements and payments within 3 months of the close of a given accounting period. You don't want publishers sitting on your rights, money, for 11 months of the year at any time. In addition, be aware that some publishing contracts provide that if a certain amount of money is not earned by the author, the publisher's duty to render a royalty statement and payment is stayed. The Authors Guild obviously objects to this, at least as far as the publisher's right not to render a statement. You should receive a royalty statement regularly, regardless of the amount earned, as long as the contract is in effect, so you can check the accuracy of your publisher's accounting, even if you've earned a low or no royalties at all. If you're going to have an earnings threshold, you want to make sure it is low, ideally not more than $50. The publisher shouldn't be allowed to hold $100 or $75 indefinitely. I think 50 is probably as large an amount as I'm comfortable with a publisher retaining. Another common feature of the accounting clause is the publisher's right to withhold a reserve against returns. For years, we had advocated to limit the publisher's right to withhold royalties as a reserve for only the first 3 accounting periods and to limit the withholdings to 50%. However, this has been largely rejected as unreasonable by a lot of publishers. They say it's too low. From what our research has disclosed, I mean, a lot of publishers will agree to 15, but anything under 35% is considered reasonable enough in my view at this point. Anything over 35% would be unreasonable to me. I know some publishers have insisted of 50% for the first couple of years, a 50% reserve. That's insane and not okay. So 35% and below, that's all right. Just keep that in mind. And most importantly, you need to make sure your contract has an audit clause. An audit clause allows you, the author, to hire an auditor who may or may not be a CPA to audit your publisher's books to make sure it's paying royalties correctly and in full. Short of bringing a lawsuit, which, as you know, can be extremely costly, time-consuming, and stressful, the audit clause is the only way to contractually ascertain whether your publisher is correctly calculating your royalties, so its presence is essential. If your contract has an audit clause, be sure to try to stipulate that if you or your representative discovers an error of 5% or more in any royalty statement, the publisher shall pay for the cost of the audit as well as the royalty discrepancy. This is fairly standard in the industry. We're next going to talk about warranties. A warranty is a promise you make about the work you're delivering to your publisher. Typical warranties include that the work is original to you, the author, and that it does not infringe on others' copyright, and that the work contains no libelous or otherwise defamatory or obscene material and does not invade another person's privacy. Generally, publishers will be reluctant to renegotiate these provisions, but if you're able to do so, try to insert the phrase to the best of the author's knowledge before any promises you make, especially those that pertain to defamation, privacy, and obscenity. Legal standards for libel, privacy, and obscenity are especially confusing and contradictory. and it'd be difficult, if not impossible, for any writer to state with absolute certainty that her work or his work does not violate, for example, obscenity laws in any jurisdiction. The most that should be asked of you is that you make a good faith effort, honest effort, to ensure your work does not violate such laws. Now, if you breach one of these warranties, then you're held accountable under the indemnities provisions. You obviously need to be aware of the indemnity provisions that will kick in if you breach a contractual warranty. Again, keep in mind that your publisher will likely resist any but the most basic changes to their boilerplate indemnities provisions. Nonetheless, you should at least inquire about the following. 1, try to stipulate that you would only be required to indemnify the publisher if a court renders a final binding judgment against you, stating that you breached the warranties contained in the agreement. 2, insert a cap in total that the publisher may withhold or recover from you if you are found to have breached the warranties. Ideally, you want to try to limit your liability to only a portion of your advance. However, this is very hard to negotiate. If you're able to limit your liability to all sums ordered in the contract, you're doing pretty well. However, publishers almost are always unwilling to cap an author's liability. You also want to make sure that they must acquire your approval of any proposed settlement of a breach that they wish to make. And you want to make sure that you get coverage under any applicable liability insurance policy of your publisher. One more thing to consider is that under these indemnities clauses, publishers sometimes try to hold royalties if a claim is asserted. You need to make sure that if they're going to withhold royalties under an indemnities provision, that the time that they can withhold such royalties is capped. If a lawsuit is not brought within 6 months to a year of an assertion of a claim, or from the moment they start withholding your royalties, within 6 months to a year, you should require they release those funds if a claim is not actually brought. So that's something to watch out for as far as withholding money. Now that we've covered these basic provisions, we're going to talk about some secondary concerns. Publication, acceptance, manuscript, option, competitive works provision, and revisions. First, we're going to talk a little bit about publication. You always want to make sure that there's a firm publication deadline inserted in your agreement within which the publisher must publish your work or forfeit its right to do so. Ideally, it should be 12 to 18 months after acceptance. We used to say it was delivery, but publishers found that too aggressive. So we've rolled it back 12 to 18 months after acceptance at most, ideally sooner. Next, we'll talk about the manuscript acceptance. As you may know, most publishing agreements will make the acceptance of a manuscript contingent upon the publisher's subjective definition of whether a manuscript is in fact satisfactory or acceptable. For years, the Guild has urged members to try to insert an objective standard under which publishers must evaluate a manuscript, using the phrase professionally competent and fit for publication. That is to say, if a manuscript is deemed professionally competent and fit for publication, the publisher must accept your manuscript. However, few publishers have ever been willing to use this subjective language. The best many authors have been able to negotiate as far as making acceptance an objective standard is to use the term editorially acceptable in place of the term satisfactory or just acceptable. Editorially acceptable adds a slightly more objective standard and eliminates market conditions as a basis for the publisher to reject work. As an example, if a similar work comes out from another publisher before your manuscript is accepted, a publisher could not cancel your contract and reject it under an editorially acceptable standard because they must only evaluate the actual manuscript you submit using that standard. We'll next talk about some manuscript revisions. Always make sure the publisher has a definite time period within which it must accept or reject your work. Most publishers are required to render this decision within 60 days after delivery of the manuscript. You also want to stipulate that if your publisher does not actually or initially find your work to be satisfactory or even editorially satisfactory, it must give you in writing comments as far as the ways in which it finds your work unsatisfactory. It must give you the time to make corrections or changes in response to these comments. In other words, the publisher should be obligated to allow you to revise your work. It should not have the option to allow you to do so. Only after you have submitted a second corrected draft should it have the right to reject your manuscript. At this time, you should either be able to keep the advance, you should be obligated to pay it back only out of the first proceeds you earn if you place this book with another publisher. We'll next talk about some option clauses. As you may know, an option clause gives a publisher a contractual right to potentially publish an author's next work even before he begins writing such. While the Guild has historically advised its members to try to delete option clauses in their entirety, many publishers insist on retaining them. Just as an aside, there really is no benefit for an author to have an option in their contract because it's only at the publisher's discretion. So definitely try to delete it first and foremost. If you want to work with the publisher again, you could always sign another agreement without being obligated to submit it under an option provision. If you cannot delete the option in its entirety, you can limit it. You can limit its applicability by defining the option work as specifically as possible. Usually, they'll say they'll use a general reference in an option clause, something like author's next book length work. We would say make that as specific as possible. You want to make sure that it's in the same subject matter as the one that you wrote under the current agreement with your publisher. Also, you want to avoid being committed to submitting a whole manuscript. Ideally, you should only be required to give the publisher a summary or proposal of the option work, not the whole manuscript or even sample chapters. You also want to establish a negotiation period that is short and definite, such as 30 days after the publisher receives the summary or proposal. If an agreement is not reached within this 30-day time period, you should be free and clear of the publisher and should not be required to submit any other offers to it so that it can match it. You want to make sure there's no right of last refusal in your option clause. This is definitely something to avoid. That's really it about options. We'll talk about competing works next. A non-competition clause prohibits the author from publishing the same or a very similar work with another publisher. While the Guild advises authors to try to delete them in their entirety, again, like options, many publishers will insist on retaining a non-competition clause in some kind of form. To limit the effects of a non-compete clause, try to define a competing work as specifically as possible, limit the time during which the clause is effective, as well as the media in which the clause is effective. If there's a project you want to undertake that you fear the publisher could reject under a non-compete, it's best to get a specific acknowledgement in your agreement from the publisher regarding that proposed project, stating that if you do undertake that project, it would not be deemed a breach of contract under the competing works clause. So yes, I mean, this is one thing that I advise authors routinely about. If there's something they know they want to do and there's a competing works clause, best to be open and honest with the publisher and make sure that it's upfront with the publisher as far as getting that exception written into the contract. Finally, we'll talk about revisions clauses. The decision to issue a revised edition almost always remains at the sole discretion of your publisher. Over my 23 years, I've seen a lot of authors have issue with this. Ideally, you want to try to retain at least a right where you can demand that they revise your work after a certain period of time. After 5 years is reasonable. If the work is the kind of work that would be revised. A lot of publishers will not agree to this, but it would be ideal to get some type of author right to revise the work as opposed to solely being reliant on the publisher's whim of deciding when and if a work will be revised. Ideally, you want the decision to be at least mutual. A few other things. Do not permit your publisher to request revisions more than once every few years. Try to negotiate for an additional advance if you're going to be revising 20% or more of the original work. If you're unwilling to revise the work and your publisher has retained the contractual right to hire another writer to revise such, try to stipulate that his or her selection would be subject to your approval, not to be unreasonably withheld. In no event should the payment of a new writer reduce your compensation below 2/3 of your regular royalty amount. You should try to retain the right to review, if not specifically approve, the other writer's work. And as to credit, your name should remain on the work unless you request its removal. Finally, and most importantly, try to stipulate that the sales of the revised editions shall not count toward royalty escalations. That's to say, do not allow the publisher to reset your royalties at the lowest level if your royalties are based on an escalating scale, if a revised edition is issued. This is a big issue that I see often, so one to keep in mind. This concludes my prepared comments, but I'm sure you have a lot of questions. I'm happy to answer as many as I can in our remaining time. So Johnny, feel free to let me know.
Thank you, Michael.
Questions are.
A few people asked if you could speak slower, but I told them you are speaking slower than you naturally.
Sorry, yep. Sorry.
No, it's okay. Everyone, there's the transcript button below, and toward the end, you can save the transcript if you want. Also, when this is on YouTube, it'll have closed captions that might be a little more accurate than the automated captions that Zoom provides. But thanks everybody for the questions you submitted. So we received about 250 questions. There's a lot of repeats, so I tried to put them together. Several people asked, what's the biggest regret that authors have from their first contract? Is there a regret or a common mistake?
Yes, the biggest regret an author has from their first contract is not having it reviewed by the guild first. Besides that,
that's true. We hear that all the time. People join before their second or third book.
That's only a half joke. But the biggest regrets would be granting all rights, not having a good out of print clause, agreeing to really bad royalty rates, not having a publication deadline in the publishing contract. These are a lot of the issues I see first time authors having. So those are things you definitely want to be, as a first time author, always make sure there's an audit clause, always make sure there's a publication deadline, always make sure there's a decent out of print clause. If the publisher won't agree to those things, walk away. At the least.
Do first time authors have a tougher time negotiating, especially on sort of the side issues like cover approval?
Oh yeah,
like that?
Sure, for sure. First time authors, your negotiating power may be low unless you're a famous person who has a sales draw outside of the publisher. On your first contract, it's good to try to negotiate as best you can, but understand that the publisher may be unwilling, if you have no track record, to negotiate much. Some publishers will blanketly refuse to negotiate anything ever with any author. Those are publishers I say definitely stay away from. Any publisher that's unwilling to negotiate anything right off the bat and tells you that is going to be very tough to deal with when a problem comes up. That's been my experience over 23 years, and that's a huge red flag warning sign to me. So if your publisher says we don't negotiate, don't sign that contract.
Are there particular issues that are really unlikely to be negotiated by even a good publisher? Or at least likely? Yeah.
I mean, you always want to focus on. Let me go back to the presentation real fast. On those beginning provisions, even as a first-time author. Let me just do the share real quick. You can still see can you see the screen?
Yes.
Okay. These are the things you want to focus on first. The grant of rights, the money, and the warranties. I mean, you as a first-time author may have other particular things like cover that you want to focus on. That's okay, do that. But these are the most important things any author should focus on. It's the money, the rights, and what you're liable for. Because if you can't get out of the contract and you're not getting paid, it doesn't matter if you have a great cover, or it doesn't matter if they're, you know, if they're selling a lot of your work, if you're not getting paid. So we want to make sure that the rights are limited, the money's good, and that your liability is limited.
Okay. Now, a lot of people are wondering about the role of the agent, the Authors Guild, and private attorneys. So could you give a little info
Sure, of
on who
course.
negotiates what?
If you have an agent, still have us review your agreement. Agents actually come to us to have their clients join so that we review the agreement in writing, so the agent has that to negotiate off of. So yes, the guild, regardless of whether you have an agent or not, you always want to go through the guild. The agent will negotiate for you. We cannot negotiate for you directly. If you don't have an agent and want someone to negotiate for you, we can certainly refer you to reasonably priced counsel who can do this. I have someone who's very good at this that I can refer people to, but I can't negotiate directly for you, but your agent can, and we can refer people out if you would like that. At the same time, I believe that a lot of people don't need to have someone negotiate their contract. I can, if you're a guild member and you have a contract, I can guide you. Well, I can't do it for you. I can answer your questions and go over responses that the publisher may send you, and we can figure out, how to respond and whether you want to accept a deal or not. That's definitely part of your legal services fee for the guild, and that's all covered in your membership.
Right. And again, if you're an emerging writer member, if people ask about this, if you're an emerging writer member, you have access to all our services except the legal advice. But if you get a contract that needs to be reviewed, you qualify for the professional membership.
Yep, you can upgrade.
Yeah, that's a simple process.
Yep.
Also, a few people asked about a good book to refer to. There's the Authors Guild Model Trade Book Contract available for free to the public on our website. So we'll make sure you have the link to that, everybody. And let's see here. A lot of people asked about film rights. Could you give us a little update on if we'll have a film and TV options model agreement?
Yeah, we are working on a film TV option model that will be released in the future. I believe somewhat near future, most likely this year, at the least this year. Yeah, we've been getting a lot with COVID and Netflix and Hulu and all these new streaming services. The movie TV option business has exploded. I've never seen so many movie TV shopping agreements in my 23 years. So that's great that our membership is really getting a lot of offers to go into multimedia and to go onto the screen. I think it's great. I think it's cool.
Yeah.
So yeah.
So we don't have the model agreement publicly available yet, but we already review those agreements.
Yes, we review film and TV options, sure, and multimedia as well.
About genres, is there anything different between fiction and nonfiction? And then also, is there any particular things to know about children's book contracts?
Cool. Genres, it really depends on the publishers. Children's book contracts in particular, a couple of issues. You're going to have an author and an illustrator, so royalties are halved. If you're a children's book author, all those rates that you saw in my presentation that you can access, you'll want to have those. Because when there's an author and an illustrator, the royalties are split between them. So like if an author is getting 10% a list and there's an illustrator, that 10 goes to 5. So the author gets 5, the illustrator gets 5. Trying to think what else. As far as the copyright ownership in children's books, usually the illustrator retains his or her rights to his or her illustrations. And the writer of the children's book will retain the copyright in the text. And that's really the only difference is really the royalties. Sometimes the rates escalate a little at higher points. I believe that for hardcovers for the children's illustrated books, it's usually like 5% to 10,000. And then 6 or 6.25% after 20,000, they cap it at that. Sometimes they'll go to 7.5, but usually I think it's between 5 and 6 or 6.5% each for the author and the illustrator for children's book hardcovers.
Okay. We received questions about foreign rights. Many authors are interested in getting their book out to the world. They want it translated. They want it published. So what's key for that?
Um,
It sounds like you
that's
want
when
to
you
be
want,
sure the publisher can, if they're keeping the rights, you want to make sure that they have the ability to make those things
right,
happen.
exactly. If the publisher's keeping the rights, you want to make sure that there's a use it or lose it, or that they're established enough to where they have, you know, for foreign rights agents that they work with regularly that will try to sell translations or English language works in foreign territory.
Okay. You talked about this at the beginning, but some people joined late. University presses, people wanted to know if there's anything different there. You
Yeah,
said it
again, with
is
you presses,
common.
the things you have to watch out for are A, copyright retention. A lot of you presses will insist on retaining copyright. B, the royalties. Again, many university presses will pay those rates for the small to medium-sized publishers. I would push for those. I mean, I do know some U presses like will even pay like list rates for like works they really want. Like they will give you assignments just for like contract. I've seen it. It's rare, but it happens. So you really with U presses want to focus on the rights. Again, with U presses, they're going to demand a large grant, an all-inclusive grant usually. Again, like you want to try to use those same limits that we advised on, retain non-print foreign and translation rights. But it's just hard to negotiate with them because they're a lot more insistent on getting all rights, taking copyright. As long as you have a good out of print, that's one thing to always make sure about in a new press contract, a strong out of print. Make sure there's an audit. Some of them don't have audit clauses. That's really it.
Okay. On a couple finer details, sometimes
Sure.
an author publishes a book and then later someone else wants to include some of it in a textbook or some
Mhm.
other publication or an app or who knows what.
Yep.
How's that handled in the contract? The author's, ability to use that same material again in another format.
Oh, excerpt rights, you mean? The publisher will usually handle that. If you grant exclusive rights to your publisher, they'll handle like permissions for use of the material. If you're self-publishing, then you could control it. So you
Right.
could allow an author yourself if they seek permission to use stuff. You can charge a fee or whatever you want.
Okay. Okay.
That's
That's
what
great.
they're asking. But
I'm sorry if you covered that in full, but
no,
I'm looking at the
not at all.
questions
Not at
full.
all.
Yeah. Yeah.
Happy to discuss.
Um, how possible is it to renegotiate contracts? When might you be able to renegotiate?
After they're executed, legally impossible. Or I'll say you don't have the legal right to renegotiate unless it's in the contract. So it can be a legal impossibility. At the same time, if you feel that you have reasons to renegotiate, it can't hurt to try. The worst they can say is no, and you're in the same position you'd be. So, I mean, as far as renegotiation, keep in mind, you most likely don't have the legal right to do it, but you always have the right to try.
Okay. For translations, often the translator historically has not kept the copyright, but it's becoming more common for the translator to own their copyright. Is that correct?
Yep.
You were
In their
saying,
specific translation, yes.
right.
Yes.
Okay. Let's see here. In cases of breach of contract, what's the best recourse? How much can the Authors Guild intervene, and what?
Happy to discuss it. Yeah, sure. If you have a breach, the first thing I would want you to do is send us a query through our website or to staff@authorsguild.org. I would need a copy of the contract, of the correspondence regarding that breach, and then I evaluate it. And once I evaluate it, I might have the member reach out to the publisher with a further demand and CC me. And then once that demand is set with CC to me, I can step in. Usually I'll want an author member to reach out first with a CC to me before I immediately jump out of nowhere and jump into something. Just so that the party sees that the guild is aware now, rather than me come directly without them knowing that I'm going to be involved. So usually I let the publishers have like a courtesy of an acknowledgement that, hey, this member is sending something to both the publisher and the guild. And then if the publisher won't respond adequately, I'll jump.
Okay. Well, I think we can wrap up in just a moment. I just want to say, everyone, again, you can click on the CC live transcript button to save the transcript if you want, but we'll be sending out the slides as a PDF, so you'll have that to look for in your email boxes tomorrow or the next day. Michael, I'll close with this question. What issues with the publisher and the negotiating process are the biggest red flags where the author should walk away from that contract offer?
No out of print, walk away. No order clause, walk away. Really bad royalty rates, walk away. Those are really the
it's difficult.
main thing.
A lot of people are very excited about the contract offer, especially if it's their first book, but
right.
Decision.
Yes. And my advice on that is you'll get another offer. Don't sign a bad contract just to sign a contract. Sign a good contract or wait to get a good contract. You can always self-publish until you get a good contract.
All right. So to wrap up, everyone, we'll send out the links, but you can search for the Authors Guild model trade book contract, model book contract, and easily find that on our website.
Yeah, it's on the front page.
Join the Authors Guild if you're not already a member. That's an easy process. And we've got a lot of helpful lawyers who have been doing this for years or even decades.
Decades in my part.
All right. Well, thanks, everybody. And again, email us at staff@authorsguild.org with legal questions or any questions about today's event. All right. Thanks, Michael. And thanks, everyone.
Thanks, everybody. Have a great day.